Okay, welcome to Chapter 7. We're going to be looking at the courts, and this really begins an entire unit, 3 chapters, looking at the court system in the United States, how it functions. And this is a chapter, or a series of chapters I really enjoy. As you may, I think I've let you know, if you may or may not know, I've been a defense attorney since I graduated from law school and was admitted to the North Carolina State Bar in 1986. So the perspective I'm going to bring here, and you should be aware of my perspective because you should question how it makes me biased when I teach or question the information I present. However, um, I think I am an honest broker here, but I mean, you're certainly free, and I encourage you to look at how I present it and the facts. So we're going to be looking at the state and the federal court systems today. The first thing, obviously, and you've seen these multiple times, is the learning objectives. These are just overall kind of goals we're seeking to achieve inside. If you use these in conjunction with reading the chapter, listening to this lecture, working on the reviews I provide, I think they're going to be very helpful to you, but you don't have to study them per se. They're really both a little bit more internal, a little bit more external for us. Okay, so it is also important as we start, particularly these broad new chapters, to ask some basic questions. Because if your book, and this is what the lecture is based off of, is the core of what we're doing, is the source of some of our information, we should build on that. And we should ask some questions about what the book's presenting, how it's presenting the information, how these lectures are. And these are questions I think that should be in the back of your mind as we talk about the court system. So the first point I'd like to focus on is the reality versus the image. Most people experience the court system vicariously. They experience it through the media. And by that I mean either through novels, people still read, I still read at least, TV shows probably more popular, movies also extremely popular, both online video and maybe someday soon back in the movie theaters. Um, and these depictions, of course, are not reality. They may be close to reality, they may point us to things, they may show us things, but they are reflections of reality. So ask yourself, how realistic is the courtroom we see? How important, which is another question. Okay, second major question I ask before beginning, who makes up the court systems? Um, every human institution is composed of human beings who make decisions, who have backgrounds. And the composition of those that make up the courts obviously are going to impact how they function and the decisions they make. Finally, since courts are intimately tied to politics, political power, political structure, the exercise of each, how does political power conflict with the ideals that we say exist in the court system? Okay, the first thing, I touched on this with a few previous, is there's going to be a micro lecture on the current structure of the North Carolina Supreme Court, excuse me, on the federal Supreme Court. It is the ultimate referee, and I think it's important going into this as I talk about the court that you know who's sitting on the court and how does the people on the court, who they are, what they believe, who appointed them, what political goals they have or state they have or don't have, how does that impact it, and what doctrines, and I had already introduced the idea of strict constructionalism and liberal interpretation, what doctrines exist to guide the courts? Okay, so your text talks about, it gives a listing of 4 potential functions of the court. Again, be a little leery when someone says there's 4 reasons for something, because those are the 4 reasons he wants to talk about, or she. And there can be other reasons, and the reasons given may be more or less important, they may be very general, they may be very specific. But here's what the court starts off as being defined by your text, and I think this is a reasonable approach, something we'll expand on. The due process functions of the court, the crime control functions of the court, the rehabilitative or rehabilitation functions of the court, and the bureaucratic functions. So the courts are the guardians of our individual rights. You can have all the rights you want, but if no one's willing to enforce those rights, they don't exist. The courts also clearly are where we punish and repress both crime and criminal conduct, which means people, because people commit crime. Also, they are involved intimately with um, rehabilitation. How do we treat criminals? How do we rehabilitate them? How do we change them from being criminals back into citizens if that's possible or necessary, or if we want to? And of course, then there's the bureaucratic function of the courts. They're going to have to push paper. They're going to have to process their workload. So there's going to be a bureaucratic system that functions in conjunction with these other more stated goals. Okay, a couple terms here, one of which isn't referred to too much in your text. The other one is jurisdiction and venue. Venue is the one that's not referred to as easily. But they're both important terms to fix in your mind. When we use the term jurisdiction as the legal system, that means which court system, and I've capitalized that in the notes, has the authority to hear the case. So if you stab someone in Billings, Wyoming, then the Wyoming court system has jurisdiction. If you killed someone in Raleigh, North Carolina, then proper jurisdiction is the court system of North Carolina. Venue is, okay, you've established jurisdiction. Now, which particular court does it go to? Obviously, if you're talking about a homicide, you're not going to hear that in small claims court. If you're talking about a bank robbery, you're not going to hear that in bankruptcy court, even though bank and bankruptcy is the same. So if a murder was to occur in Raleigh, North Carolina, proper jurisdiction would be the North Carolina courts, but the proper venue would be the Superior Court, County of Wake. That would tell you what judge you're going to go in front of. So jurisdiction is the system, venue is the specific court. Okay, how do you establish criminal jurisdiction? Now, jurisdiction also exists civilly, which can be a little bit different, but we're going to focus on criminal jurisdiction. So 90 times out of 100, I would say probably 99 times out of 100, jurisdiction is going to be based on geography. Where did the crime or some part of the crime occur? So if you kidnapped someone in Raleigh, North Carolina, took them to Lizard Lick and killed them, that crime occurred solely in North Carolina, and North Carolina would have jurisdiction there. If you killed someone, the example I give in Miami, Florida, even if it was a North Carolina native, let's suppose that I'm on vacation in Miami and I am killed in Miami. The trial is not going to occur in North Carolina. The trial is, even though I'm a North Carolina native, the trial is going to occur in Florida. Now, in rare cases, very rare cases, subject matter, crimes based upon what they are, can change jurisdiction. Most of the time, this is going to be pretty rare in the criminal process. We could look at bankruptcy fraud. I mentioned that. Bankruptcy is solely a federal matter. If you had committed bankruptcy fraud, the proper jurisdiction is not the North Carolina courts. Even if you did it solely in North Carolina, it would be federal. Also, there's some crimes that are really defined just federally. An example there would be terrorism. Committing an act of terrorism, even if it was completely inside North Carolina, you're likely, because of the subject matter, to be tried in federal court. Although conceivably, if you killed or hurt someone or committed a violent act, North Carolina would have concurrent jurisdiction. Okay, trial courts and appellate courts. Now this is really the beginning, I would say, in this chapter, of a couple surprises for people, because most people don't really understand how appellate courts work. So let's take the first type of court here, and then we'll get to the real changing. Trial courts. Now this is probably what the vast majority of the population think about when they think about a court. They're properly called in the law courts of original jurisdiction. That means that this court will hear evidence to establish what is true, what is false, and then they'll make a ruling as to it. And that ruling in criminal cases will be guilt or innocence. Appellate courts are different. Now, a trial court, for example, in Raleigh, North Carolina, we have if we exclude the magistrate small claims court, we have two basic types of trial courts, superior court and district court. Appellate courts, however, up from them, we have the North Carolina Court of Appeals, the North Carolina Supreme Court, we have the Federal Court of Appeals, sometimes called Circuit Court, and we have the United States Supreme Court. The interesting thing about appellate courts is, first of all, they do not rule on facts. They rule on issues of law. You do not appeal a decision from an original jurisdiction court, a trial court, to an appellate court by saying, oh, the facts are wrong here. They got it wrong at trial. No, you have to appeal based upon an error of law. And these appellate courts will write their explanations, and these explanations under the law are called opinions. Okay. You also should remember that we have two systems working side by side with each other. We have the state courts, which enforce just the state laws, and then we have the federal courts, which enforce federal law 90% of the time. As I kind of mentioned before when I talked about a few things, sometimes an act is both a violation of federal law and of state law. So let's take a horrific example. In 1963, in November, the President of the United States, John F. Kennedy, was assassinated in Dallas, Texas. That was a murder committed inside the state of Texas. Texas would have jurisdiction to place him on trial. Oswald was the name of the person that shot him. Now, it's also, if you look at statute today, I'm not sure in 1968 or 63, it's also a crime, a federal crime, to kill the President of the United States or threaten his life. So both the state of Texas and the federal government could try him for a crime. And I can hear some of you already saying, well, wait a minute, Professor Chapman, the Constitution forbids double jeopardy, being placed on trial twice for the same crime. To which my answer would be, yes, but only if it's the same state doing it. The feds and the state can both try you for the same act if it's a different crime federally and the state. Okay, I give you here this slide. This slide is not in your text. I think it's important for you guys to know. This is the structure of the North Carolina court system. So if you'll notice, starting at the top here, if you follow the arrow, we've got 7 Supreme Court justices. We've got 15 Court of Appeal justices. We've got 109 Superior Court judges, 256 state district court judges, then we've got magistrates, we've got some court administrators and clerks of court. This is a pretty common structure, a little bit different. There's a few small things that are different about that, but this is basically how the pyramid that is built of the North Carolina court system. Other states will use sometimes different terminology. Weirdly enough, if we took New York doesn't call its district court, which is its basic trial court in North Carolina, it doesn't call it the district court, it calls it its Supreme Court for whatever reason. So North Carolina has 2 trial courts. Remember, these are courts of original jurisdiction. District court, which if you're a practicing attorney, you spend a lot of time in district court. District court handles your minor criminal cases. There usually are, there are no juries in district court. It's going to handle most criminal cases because most criminal cases are very minor. So if you're looking at a traffic ticket, if you're looking at a quick plea, if you're looking at a simple assault, those are all going to be in district court. Superior Court in North Carolina is going to handle your felony cases. If you've got a murder, if you've got a rape, if you've got a serious arson, that's going to be tried in Superior Court. Stepping up from there, the appellate courts, the North Carolina Court of Appeals, and the biggest of the big dog in North Carolina, the North Carolina Supreme Court. Be aware that all North Carolina judges, whether they're in District Court, Superior Court, Court of Appeals, or Supreme Court, are elected officials. They run for a period of term, usually 4 years for your District Court judges and longer for others, and are elected every 4 years. So you select them, you, the public. So we also have magistrates. Magistrates are not elected. Magistrates handle very minor matters, things that go on. They'll do some setting bail. So if I get a phone call on a Saturday night and a client's been arrested and I go down, I'm not going to go in front of a sitting district court judge. He's not going to be there on a Saturday night. There is going to be a magistrate. So recently, not too long ago, I had a client who was arrested at the airport on Saturday because he forgot and he left a knife in his carry-on bag. He was a rock climber and he had it to cut ropes and forgot about it. They decided to press charges. He was arrested. This was near Christmas last time I was down there. He was arrested. He was brought down on a Saturday, the Saturday before the Christmas. Trust me, there's no district court judge there. There were only magistrates. And the magistrate set a bail to release him. So magistrates are appointed by the senior resident superior court judge. They serve first 2 years, then a 4-year term. These, they do a lot of the work. They do a lot of the grunt work, processing a lot of paper. Very important in the system. Now the federal court system does not have 2 trial courts. They don't have a federal court that handles the misdemeanor federal crimes and a federal court that handles the superior. There's just one federal court trial, and that's the federal district court. But they do have, like North Carolina, 2 appeals courts. The U.S. Circuit Court of Appeals and the United States Supreme Court, which is the most powerful court in the land. And you're going to get sick of hearing about that, but it's absolutely true. All U.S. federal court judges are appointed by the President and confirmed by the Senate. Now, traditionally, what would happen is the President often would consult with the senators of the state. They would make maybe a recommendation, but the President of the United States would find someone that he deemed qualified, which usually meant they met the minimum qualifications. They had to be usually an attorney. They were not always a practicing attorney, particularly for the Supreme Court. And then since he was recognized as quality, he went in front of the Senate, and the Senate might not like him, but they would confirm him if he was qualified. That's, in the last 20, 30 years, that's changed. It's very much now the President, if he's of a different political party than holds the majority in the Senate, won't be able to put people on the court. The Senate will just refuse. So this is the structure of the federal court system, and you'll notice that there are 94 district courts. That's where most of it. There's a few other courts. There's a tax court, territorial courts. There's military courts. You got courts of international trade over here. There's a court of veterans appeals, U.S. claims courts. You got a bunch of these kind of stranger courts. Don't impact it too much. You got U.S. Court of Appeals and the United States Supreme Court. This is a breakdown of the Circuit Court of Appeals. This is that second appeals court before you get to the United States Supreme Court. We are in the 4th Circuit, where with South Carolina and Virginia, God help us, reminds me of a quote. You have to live with my quotes. You know, North Carolina is the valley of humility between the 2 peaks of arrogance of Virginia and South Carolina. Not to pick on South Carolina and Virginia too much, but I prefer North Carolina. We are not the most important circuit court. We're pretty important because we've got Virginia, and there's some bleed over from Virginia being important. It hears some important cases, but the really important ones are typically the ones that have big populations or big industrial centers or big financial centers. So obviously the 9th Circuit with California, the most populous state, a lot of important law comes out of there. The 5th Circuit with Texas, a lot of death penalty cases come out of there, very important criminally. The 2nd Circuit, New York, being the financial capital of the United States, very important. So the 2nd, the 5th, the 9th, very important. Some, frankly, aren't that important, like the 10th. Not a lot of law comes out of the middle of the country like that. The 8th, the 7th, the 6th, the 4th, the 3rd, those are pretty important, even the 1st. Okay, there is a fight to control the bench that's ongoing. And in the second one of these micro lectures that I'll provide for you, I'll talk about this fight to control the bench because many of my students don't understand this. They figure, well, the president just picks who he wants, or it's different things. So I'll talk about that. And you have some issues about the struggle to control the court and why it's so important. Who should be on the court and why. Okay, this is another one of those things that comes as a bit of a shock to people. Error of law versus innocence. Most people will think, if they think at all about it, they'll say, well, you know, if you're convicted at a court and you didn't do it, you appeal and you say to the court above, hey, look, I'm innocent. And that's an interesting theory, but it's really not how law is done. So I'm going to tell you something now, that courts of appeals do not, and I can't emphasize that word again, not concern themselves with innocence. Court of Appeals does not want to hear a defendant saying, I'm innocent. If you are going to appeal, you have to show that there was an error of law. Now, granted, and this is where innocence comes into play, you can argue that the error of law, if it hadn't been made, would have shown you were innocent. So here would be an example. You appeal to a superior court and you say, from a court, you appeal to a Court of Appeals of the U.S. Supreme Court and you say, I was convicted at court because there was a coerced confession. The police tortured me to confess. Now, the Supreme Court of the United States is not going to say, okay, you're innocent, free to go, goodbye. What they would say is, since they violated your Fourth Amendment and Fifth Amendment rights against self-incrimination, there was a violation of your rights and you are entitled to a new trial. So they will send it back down and they will say, have another trial with them. Now, very often the state will say, well, we can't because we don't have any other evidence, and they'll let you go. So the effect might be the same, but you don't appeal on innocence. The other thing, and too many people watch TV and movies and they say, oh, people appeal and appeal and appeal and no decision's final. Well, only about 10% of cases that are appealed are successful, which means 90% of the time the decision, even if it's appealed at the trial court, stands up. And you got to remember that most cases are never even appealed. So it's an even higher number. All right, the United States Supreme Court. There are, and this is a traditional number, 8 associate justices and 1 chief justice. Now, they have the power to shape law in the United States, and this is through the process, which we're going to talk about in a little bit, of judicial review. One of the things you should be aware of is, of all the cases in the United States, you know, let's just take homicides as our example. There's about 20,000 homicides. We solve about 65–70% of them. So there's maybe 7,000 homicides that occur in the United States every year that are trials. Even if all of those were appealed, and they're not, to the United States Supreme Court, the United States hears a lot of other cases that aren't related to this. So there's only 7,000 cases that get up to the Supreme Court every year. And most of those are not going to be murder cases. They're going to be cases like employment cases or international trade or different things. So even if you manage to appeal to the Supreme Court, they only hear between 100 and 150. So that means that even if the only thing coming up were all these homicides, let's suppose that every homicide got appealed to the Supreme Court, only 100 to 150 of that 7,000 would be heard by the court. So the odds of a case getting to the Supreme Court are very, very small. In part, this is because you have to get at least 4 of the justices, 4 of the 9, that will agree to hear a case. If they won't hear it, it's not going to be heard. Okay. We're going to talk about something that is kind of a unique American invention, and this is the power of judicial review. This is something that the Supreme Court uses as its primary power to shape the law. The court can get a case that comes up, they can look at it and they can say, we don't like this law. This law is unconstitutional. It's overturned. So an example here. In the 1960s, a man named Gideon was arrested, and he was too poor to have an attorney, and he was tried in court, convicted, sentenced to time in prison. And he appealed to the United States Supreme Court and said, look, I was too poor to have an attorney. And the Supreme Court heard it under judicial review, and they said, if you're actually going to go to prison in the United States, you should, rich or poor, be entitled to an attorney. And if you can't afford one, one should be appointed for you. This is the famous case of Gideon v. Wainwright. If you're interested, there is a book called Gideon's Trumpet. It's a pretty old book by now, but it's pretty good. It gives you a nice overview of the case. So the Supreme Court of the United States said the law that says you can have a trial without an attorney, if you can't afford one, is struck down. It's unconstitutional. That is an exercise of judicial review. Now, it doesn't happen very often. It has been happening with increasing frequency compared to how it happened in the beginning of the American Republic, but it's still a pretty rare thing for the court to do. How did it come into existence? Is it part of the Constitution? Is it a natural power? How does it interact with different judicial philosophies? Well, I'm going to save those points because we'd go down a real rabbit hole here for the third micro lecture in this chapter. Suffice it to say, it came into existence from a very early case in the history of the Supreme Court, and really has laid dormant for a long time until the middle part of the 19th century. Okay. Law, not evidence. The Supreme Court of the United States does not hear evidence. So you don't go into the Supreme Court and say, here's Bob's testimony about the murder. What the Supreme Court hears is written arguments, and we call those briefs, from the different lawyers, the two sides. Now, often they have oral arguments. They bring the lawyers in and they say, okay, tell us what you think the issues are here. We've read your briefs. When the Supreme Court hears the oral arguments and reads the brief, they go back and they discuss the case and they vote on it. If the Chief Justice is in the majority, he decides who gets to write the opinion. Remember, the opinion in this meaning is what the decision of the court is, the written decision. If the Chief Justice is not, then the most senior sitting justice that's in the majority gets to decide who writes the case. If you don't like the case, you can dissent from it. So if you're in the minority, suppose it's a 5-4 decision, and you're Justice Ginsburg, you say, well, I don't like this decision, then you can write a dissent. You can say, I think the majority's wrong and here's the reason. These dissents are important because these dissents later can become the basis of a change in the law. You also sometimes, the majority, let's suppose it's a 6-3 majority or a 7-2 majority, they all might write an opinion, or someone might write an opinion. You say, well, I agree, but there's really a different reason why this occurred. Then you also can write an opinion, and that's called a concurrence or a concurring opinion. All right, let's drop back from the lofty heights of the Supreme Court and talk about judges. Here's an old joke in law school. What do you call the person who graduates with the worst scores in law school? And the answer is Your Honor. The judge is kind of a difficult figure for many people to wrap their minds around. I speak to a lot of students who say, oh, I want to be a lawyer because I want to argue, and we don't do that as much, and certainly judges don't. Or I will have students come up and say, I want to make a lot of money, and lawyers get rich, which, again, is not really true, but one of the ways I'll warn you is you're never going to get rich being a judge. So judges really are bureaucratic in many ways. They perform a bureaucratic function. So what do? Well, they really have three unique phases. First of all, before trial, judges want to try to get you to settle. So you're going to be talking to judges. The judge is going to be reviewing evidence. He's going to be talking to you, and he's going to be kind of pushing you to settle. Maybe not a lot, maybe not at all in certain cases. But they will spend a lot of time working with the prosecutors and the defense attorneys here. Now, also to be honest, because they're going to see the prosecutors much more often, judges tend to have a friendlier relationship with the prosecution. At trial, when the trial starts, the judge is supposed to be neutral. He's much more of a referee. Now, he can be a teacher also. He can explain points of law to the jury and read them instructions and stuff. But he's supposed to be very neutral. He's also responsible for ensuring that the law is applied and followed in court, both the procedural and the substantive law. Finally, he's got responsibilities for the day-to-day functioning of the court, their particular court. They're going to have a court calendar. They're going to have a number of cases on those calendars. They're going to have to process some of those so that the court system doesn't become backlogged. Okay, one of the issues is the diversity of the bench. Most judges are white men. Now, men represent 50% of the population, so you would expect that there would be a significant number of men. Whites represent about 70% of the population, 60 to 70%, let's just say 70%. So half of 70 would be, since 35. So if everything was equal statistically, white men should be about 35% of the bench. They're about twice that. So women and minorities are notably absent on the bench. Well, why is that important? Well, there is certain benefits to it. One of which is, if you have a community that's being policed and judged by different racial groups, different ethnic groups, the ground is fertile for a belief that a lot of prejudice or unfair procedures. The other thing is, it really enriches a judiciary when it experiences a variety of perspectives and positions of power. Let me give you a benefit that you, I think, would appreciate more, because most of you are a good deal younger than I am. The youngest generation growing up now, I guess we're at Generation Z, is much more technologically savvy than the older generation. My generation, which is, I was born, believe it or not, during the Eisenhower administration. So that's the beginning of the end of the baby boom. You guys are much more familiar with technology. If you've got a bunch of people sitting on the bench like me, older white men, we may not understand how Twitter works, how emails work, and we might misunderstand the application of it. I mean, if you went to a lot of older white men and you said, "What's TikTok?" They would say, "Oh, it's a nursery rhyme. Tick-tock, the mouse ran up the clock." They may never have heard of the TikTok app. They may not know what a meme is. So just based upon the fact that most judges are old, that's going to affect how they understand the world they live in. If you've got younger judges, they might understand, oh, you insulted him online, or you posted something on a blog. Oh, I know what a blog is. So diversity enriches the bench by letting them understand more. Okay, you should also understand that the courtroom work, for all the sort of fights you see between prosecutors and defenses and judges, it's a more cooperative unit. It has its own subculture. The three most prominent members, the judge, the prosecutor, the defense attorney, the three of us have a lot in common. Very often, I will go into a courtroom and I will know the judge. I might have gone to law school with him. I might have known the prosecutor. He might be a friend of mine. The same with the judge. We speak the same language. We've had the same education. We come from the same background. So I have a lot more in common, in a certain sense, with the prosecution and the judge than I do with my client very often. Now, there are other people inside There's the bailiff in North Carolina, for example. The sheriff of the county within which the court sits is required to provide security for the court. So in almost all courtrooms, you're going to see a sheriff's deputy. You're going to see a clerk of court and a court reporter. Sometimes they're the same thing, but they're going to process the paperwork and they're going to keep the records. Okay, so the judge in theory is the most powerful person in the courtroom. Now that's not true in North Carolina. North Carolina, we've ceded a lot of the power from the judge to the prosecutor. I think it's fair to say, and I don't think too many people would dispute this, that the prosecutor in setting up the trial, in calling the trial, has the most power. Now, judges, it really matters what their personality is. Judges can have amazingly different points of view and personality. So a quick example. We used to have a judge on the bench called Jerry Leonard. Sat in district court here. Jerry was a very patient judge when it came to juveniles. So if you had a juvenile client, Jerry was a great judge to get him in front of. He would take time, he would listen, he was really interested in rehabilitation. That reflected his style. There are other judges, some of them on the bench today, that are kind of no nonsense. They don't want to hear your issues. They really believe in punishment. So it mattered a lot. Like, get him in front of Jerry Leonard, or did he get in front of one of these harder judges? Now, one of the interesting things that's happened in my lifetime is that more and more judges are ex-prosecutors. In the past, it was very common that judges were defense attorneys. Now, if we look federally, 4 out of 5 judges, or 80%, are ex-prosecutors. 7 out of 8 are former attorneys that work for the government. Only 1 out of 16, which is a really shockingly low number, are defense attorneys who never worked for the government. So if you are a product of your environment, then your judges are a product of the prosecutor's department. Okay, let's talk about the prosecutor. As I said, in North Carolina, it's not as true in some other states. The prosecutor is the most powerful figure. Why? Well, here's what he can do in North Carolina. First of all, and this is really astounding, he controls the calendar. He decides the setting of cases. He decides when they go forward. It's not the judge, it's the prosecutor. But more than that, he decides what charges are filed. Now, it's up to the prosecutor, and he goes by a different name. In North Carolina, we call him the district attorney or the assistant district attorney, ADA. He's the one that gets the evidence in and says, okay, I'm going to charge or I'm not going to charge. Now, sometimes grand juries are used, but not in North Carolina very often. So this is an immense amount of power, and it's basically an unreviewable decision. And you can see how this can impact it. Floyd George in Minneapolis was killed by a police officer recently, and we've had some riots because of it. Well, one of the things that kind of triggered these riots is, was the DA going to charge? You know, there were cases of a Georgia case recently where 2 district attorneys declined to charge individuals who were ex-police officers who killed a black man. Now, whether he's guilty or not, I don't really want to argue that. I want to argue that the decision not to charge is the important thing here. He can decide when to go to trial. He can decide when to drop charges. The other thing is they work in tandem with the police. So he largely controls how the police investigate and handle evidence. They have large resources. They have a very large staff. So they are very, very powerful. Typically, the way that prosecutors are evaluated is based on their conviction rate. So we're coming up to an election soon, and you're going to hear prosecutors running for office, and they're going to say things like, I'm going to lock them up and throw away the key. I get a 90% conviction rate. Okay. ADAs, assistant district attorneys, are often judged on how many of their cases they win. But the prosecutor has a legal duty not just to convict, but to prevent wrongful convictions. One of the ways in which they can shape the entire trial is they control the evidence. Since most of the time, defense attorneys are court appointed, which means the defendant is poor. They don't have the resources to hire private investigators to do independent studies, to gather up evidence. So almost all the evidence is going to be controlled by the police and be filtered through the prosecutor's department. That means they can decide what to share with the defense. Now, in theory, under something called the Brady Rule, they are supposed to share any evidence that shows guilt or innocence of my client with me. And I will say that for most of the district attorneys around here, I have no complaints. The Wake County District Attorney's Office has been wonderful. They have an open file rule. They will share. But some prosecutors simply fail to comply with this. They won't turn over evidence. There might be evidence in the police file that says, oh, someone else's fingerprints were found at the scene of the crime. But we're just not going to tell the defense attorney about this. The amazing thing is, even though they have this duty, they're largely immune from lawsuits for misbehavior. All right, the defense attorney. What's my job? My job is not to prove my client is innocent. My client starts with the presumption of innocence. My job is to make sure the government has proved guilt. So if they can't prove my guy did it, you got to let him go. Not that he's a great person, but could they prove he did it? I am the only voice in the courtroom for the defendant. Now, if you face incarceration, you have the right to an attorney, even if you can't pay. That's the case of Gideon v. Wainwright I mentioned a little earlier. And of course, defense attorneys should be reasonably competent to do their job. So what do I do? Well, I can investigate the incident. One of the things that I will do if I'm a defense attorney is I will get the police report or I will get the information and I will look at the facts that were gathered. Now, like I said, because most people are poor, I can't hire a private attorney, so I have to rely upon what the police found. I engage in plea bargaining. That's mainly what a defense attorney does. I love trials. Trials are fun. Trials are exciting, but they're rare. I prepare for trial if we have it. Now, most trials are not won at trial. Most people think, well, the trial is what really matters. I hate to tell you, but really it's before trial. It's the motions you make. What witnesses are going to be allowed to testify? What evidence is going to be placed into the record or in front of the jury or judge? If it comes to trial, I will stand next to you. I will represent you at trial. I will, if you're convicted, negotiate a sentence, and of course we can decide to appeal or not appeal. There are two types of defense attorneys. Private attorneys, and these means you have the money to hire someone, or public defenders in some way, shape, or form. About 90% of criminal defendants are provided counsel, so in some way. And every jurisdiction has different eligibilities for us and how it works. I've been sitting in courtrooms when a judge just looks out at the courtroom and says, you're going to represent this guy. It's like, okay, Your Honor. Your book says conviction rates for defendants represented by those publicly funded are similar. That's somewhat true, although I take that with a grain of salt. So the big issue here is that the public is cheap. And I understand that. I'm part of the public. I don't love paying taxes. So they don't want to give a lot of money to public defenders. After all, the logic kind of goes like this. Well, they're working for the bad guys. They're working for the guys accused of crime. So why would you give them a lot of resources? Let's give it to the prosecutor, and the prosecutor can prove they're guilty. Okay, great. But remember, your presumption of innocence. So there's not a lot of resources given. Here's an example of a public defender in Lafayette, Louisiana. He was assigned 194 felony cases in 2017. Now, This is a lot of work. High-level felonies require about 70 hours of legal work, mid-levels 40, life sentences 200. Those 194 felonies means that public defender was doing 5 times the amount of work that he should have been doing. Simply because Louisiana said, well, we're not going to pay for any more, and you're going to represent him, and too bad, so sad. There is a link to the American Bar, which is a neutral organization about the public defender there. Okay, so is the fix in? Does the extreme underfunding of the public defender system undermine our very system? And you have to ask this question. The adversarial system that we have relies upon each side presenting evidence and some neutral figure, the judge or the jury, determining what's guilt or innocence. But if you strip down the resources available to one side and give the other side more resources, more power, it's not an equal system. And you have to ask, is the system too biased towards the prosecution? All right, attorney-client privilege. One of the things I tell my clients when I talk to them the first time is, whatever you tell me, so long as you're alive, whatever you tell me, you are exempt. It is never going to be disclosed to anybody. Now, there's a couple of exceedingly rare exceptions to this. There's the United States Supreme Court case of U.S. versus Zolan, which says if my client tells me he's going to go forward and kill someone or commit a crime in the future, I have a duty to disclose it. But past crimes are not. What you tell me what you did in the past stays with me and just with me. This one is kind of sad for me, the end of trials. When I first started practicing law in 1986, about 25% of my cases, my criminal cases, would go to trial, which meant I was in district court weekly and in superior court at least every month. Today, only about 3% of cases go to trial, and that means the vast, vast majority are being plea bargained, and you have to ask yourself, as part of those fundamental questions we ask at the beginning, why is this so? All right, on that note, we've come in at about 50 minutes. We've got those micro lectures that'll bump it up a little bit if you want to listen to those, but other than that, I hope you enjoyed this lecture, and I hope you're having a good day or evening or night or whenever you're listening to this. Good night.